All right, we will let's go ahead and get started here. As I said, welcome you all to the to our webinar dealing with legalization of marijuana, recreational marijuana, if you will, in Ohio, and how that's going to impact your employees and your workforce policy. So obviously, this is a big hot topic issue in Ohio right now, and honestly, it's going to become even a hot topic issue nationwide if you're presently not in a state that allows recreational marijuana. It's only a matter of time. We expect Pennsylvania and Florida to potentially go with recreational legalization this year as well. So definitely timely for everybody. But before we get started, my name is Brian Meek. I am the co-chair of our labor and employment division here at Brennan Manna and Diamond. I am a partner employment attorney here as well. So I've been dealing with this issue and how it's impacting employees since legalization occurred back in November. But we'll get to all that stuff here in a moment. Before we get started, I do want to say, although some of the participants here today may be our clients, but generally, we're lawyers. We're not necessarily your lawyers yet. So this presentation shouldn't be taken as legal advice. It's really meant more for background information and kind of like a general question and answer to answer questions you all may have. But either way, if you'd like to touch base offline in a more attorney-client type relationship with protected communications, we can definitely set that up. My contact information will be at the end, so feel free to reach out to me at that time. So where does things stand right now today regarding marijuana in Ohio? Well, as I kind of teed up, and I'm sure most of you on our webinar know that adult recreational use of marijuana is now legal in Ohio. It has been since December 7th of last year. It took effect following the passage of a citizen initiative in the November election, approving recreational use nationwide. What's interesting, however, is so we've legalized marijuana in Ohio, but there's nowhere for people to purchase it. So they'd have to go to Michigan to get it and bring it back into Ohio, which presents its own legal issues, or continue to get it in their less than legal ways, from their friends, things like that. So with that being said, there still isn't this widespread use, right? Because there's no legitimate way to purchase this marijuana. But that's all going to change. And as I have here on the slide, we are expecting recreational storefronts to begin opening here in about 3 to 4 weeks. Likely by mid-June. I know that the applications for those storefronts are going to go out here in probably the next week and a half, and they're saying about another 2 weeks to approve thereafter. So for a lot of these storefronts, they already are selling medical marijuana, so they're just going to be able to flip a switch and immediately start selling recreational marijuana. So here in about 3 to 4 weeks, you need to start preparing for, your employees, more of your employees and a greater percentage consuming legal marijuana in Ohio. Therefore, if you're going to begin to make policy changes to, drug testing, drug use policies, things like that we're going to discuss here today, you're going to want to be getting those in place here very soon and begin educating your employees about those policy changes. But we'll get to all that here in a moment. So obviously that concerns recreational. Ohio really has had legalized marijuana for the purposes of medical treatment dating back to 2016. So that's what's here on the slide as well. So since September 8th, 2016, and people with certain medical conditions were able to purchase and consume legal marijuana. It took a couple of years to get that medical market up and running. I think it didn't really go on board until about 2018. So Ohio, this is, the use of marijuana in some fashion is really not a stranger to the state of Ohio. We've been doing it for a while, but it's just now the issues can become, it's more widespread. And in fact, I just saw an article this morning, I believe it was from the Associated Press, that it indicated that the daily use of marijuana now surpasses the daily use of alcohol for U.S. citizens. So definitely something that needs to be on the forefront of every employer's mind. But with that being said, what is the current regulation of marijuana in Ohio? Well, as I have on the screen here now, under Ohio law, employers are not required to permit or accommodate an employee's use, possession, or distribution of marijuana in or out of the workplace, right? Even as medical marijuana. So to quickly sum that up, regardless of whether it's recreational or medical, even with the passage of last year's statute, employers can still prohibit the use of any type of marijuana by their employees, whether that use occurs outside the workplace or obviously during the workday. you're going to have that freedom. You can continue to refuse to hire, discharge, and discipline employees for using medical or recreational marijuana. You don't have to change those policies necessarily. And obviously, employers can continue to prohibit employees from being impaired or under the influence of marijuana at work as well. That's not changing. So that all sounds easy, right? Hey, we'll just continue to keep status quo. We'll continue to go forward with the way we want. And honestly, after the passage back in November of recreational marijuana, a lot of our clients called us and said, hey, we want to continue to prohibit the use of marijuana by our employees. We don't want anything changing. We don't want them doing this at home. We don't want them bringing it to work. We don't want it being under the influence, et cetera. And so, we began working with our clients to review their policies and make sure they're truly reflecting what they desire. And then the funny thing happened is about a month or two later, we began getting calls back from those same clients, those same employers saying, hey, we actually need to talk about revising our policy. We're starting to get applicants or candidates who are testing positive for marijuana, and technically under our policy, we can't hire them, but we really want to hire them and it's legal now. So we don't know that we even care anymore. And I said, well, 2 months ago, you said you're going to follow it this way, but now obviously with the widespread use, you're going to shift, right? And you're going to begin to consider what policies might be appropriate for your workplace to allow that recreational marijuana. So we've begun really working with our clients over the last couple months to really fashion a policy for them that truly achieves what they're desiring. And we're going to get into some examples here in a moment. But really, those policies really run the gamut. We still have certain employers that are like sticking to the way their policies used to be: no marijuana by anyone, regardless of whether it's recreational, regardless of whether it's medical. We don't want anyone using marijuana. So we're just going to reaffirm that in our policies. We now have certain employers who say, you know what, we're not going to allow recreational marijuana, but if someone is using it for a medical purpose, and we can confirm that they have a medical marijuana card and that they have these underlying health conditions, we'll allow that use outside of the workplace. They still can't be under the influence at work, can't bring it to work, et cetera. And then you have other employers too, kind of the third bucket, which is more like, we don't care what you do at home in terms of marijuana, whether it's recreational or medical, we don't care. Just don't bring it to work and don't be under the influence of it at work. And kind of more of a traditional alcohol type policy, right? Where you don't care if your employees have glasses of wine in the evening when they go home, just don't be under the influence when they get to work. Don't bring the wine to work. So that I'd say that's where a lot of our clients are beginning to shift, is more of that, just, whatever you do with marijuana at home, you leave it at home, you do it at home, don't bring it into the workplace. So that's really where the shift is. Now, we have some clients who are, particularly we handle healthcare type clients, but we also do a lot of manufacturing and servicing manufacturing clients. And a lot of them will say, hey, look, we don't mind if our, inside sales team or, our accounting division or, more of the office type positions use marijuana at home. We don't care. But we don't want to allow our factory workers to do it, because there's still that risk, right, of whether those employees might still be under the influence after the night before, and whether they're actually under the influence at work, despite saying they're not. We don't want that, that OSHA risk or that workplace injury risk. What can we do there? Well, under Ohio law, you can actually differentiate by position. So you can say positions X, Y, and Z, you still cannot use marijuana at home. We're going to continue to test for it, but positions ABC, rather, you can use marijuana at home. We don't care, and we're not going to test you for it unless we have reasonable suspicion that you're under the influence while at work. So you can differentiate your positions and really groups of employees, as long as you're not making that difference, that differentiation based on a protected class. Just kind of an extreme example. You can't say, hey, all the women do whatever you want at home, but men, you can't consume marijuana at home. As long as the line there isn't based on a protected class, you're going to have that freedom to really state who's allowed to use and who's not allowed to use based on their position. So again, just kind of, I guess I precursored this a little bit, but what if my employee has a medical marijuana card? Under both the prior medical marijuana statute and the recreational marijuana statute that passed back in November, employers can still prohibit the use of marijuana, even by those that have medical marijuana cards. And the reason for this is because under federal law, obviously marijuana still remains illegal. We're going to get to some breaking news on that coming up. But under federal law, currently marijuana remains illegal. So you don't need to worry about accommodating the use of it for a medical reason, say under the Americans with Disabilities Act. Similarly, in Ohio, the statutes actually specifically state that employers do not have to accommodate the use of medical marijuana, even in the form of, say, a disability accommodation. So employers kind of have that get out of jail free card there to really, again, continue to make the policies that they feel are best for them when it comes to medical marijuana usage. So employees, though, shouldn't be using their medical marijuana card as a get out of termination card, if you will, saying, they never disclose it to you that they have this medical marijuana card. You do a reasonable suspicion or a random drug test or even a pre-employment test. It comes up positive for marijuana. All of a sudden they're saying, hey, look, no, I got this card. I'm protected. You can't fire me. Well, that's all fine and dandy, but our policies state that under no exception can you use marijuana, and you certainly didn't disclose it to us ahead of time either. So your options and freedom are really going to be there to deal with those situations as you wish. I also do want to state as we get going here that we really intend on this webinar to really be conversational, if you'd like. So feel free just at any time during the presentation to throw your questions into the chat box, and we'll answer them as we go. So again, just reiterating that there is this employer discretion, to really make the policies and draft those the way that you'd like to see. They're really running the gamut based on clients. So whatever you want to have done for your workforce, we can draft it up and we can achieve that for you. One thing I do want to state before we get into drafting those policies is there's now an issue, and you're probably going to begin to see this if you haven't already, where employees are utilizing CBD type products that are 100% legal at the federal level, 100% legal at the state level. They actually fall into this legal loophole, if you will, that came out of the federal 2015, I think it was called the Farmers Act, or the Farmers Bill, that essentially states that CBD based products, imagine your lotions, your creams. I know they have CBD makeup now. It really runs the gamut of these CBD type products. As long as those products contain less than 0.3% of a THC, either like, for example, Delta-9 being the most prominent, as long as it contains less than 0.3% of THC, it's going to remain 100% legal at the federal level for any age group to purchase. No license required, no minimum age required. You can purchase those products. And the thinking back in 2015 was, well, hey, 0.3%, that's a very low amount. That's almost, not going to be of an intoxicating amount for the THC. CBD itself is not intoxicating or mind altering, if you will. What's the harm? Well, over the last couple of years, we've started to see people play into this loophole. And because that 0.3% THC is based off of weight, companies are 100% fully, this is all illegal, all legal, are able to manufacture, say, gummies, right, or little gummy bears that are say a gram in weight. Well, 0.3% of a gram is 3 milligrams of THC. A standard gummy out in, say, Colorado or California for recreational based marijuana, and what we'll soon have here, is going to be 10 to 15 milligrams. So you might find situations where your employees are taking these 100% legal CBD products, consuming them, say at a rate of 1 to 2 to even 3 of them at a time, and it's going to create an intoxicating or mind altering effect similar to that of traditional recreational THC. So you have to account for those hemp CBD based products in your policies as well, to ensure that employees are aware that that your prohibition on, for example, being under the influence at work or consuming these products at work also go to CBD based products. We don't want a situation where, you go to do a reasonable suspicion test, someone tests positive for THC, and they turn around and say, nope, hey, here's my package of completely 100% legal, federally legal gummy bears that are CBD only and contain less than the 0.3% THC, because it's still going to have that mind altering effect, right, based on the size of the gummies. So that is something you're really going to want to account for in your policies as you consider how best to move forward. So again, employer best practices here. A lot of these, again, will go into the policy side of things, but employers should be creating detailed workplace policies regarding drug testing and the use of drugs, including marijuana or alcohol, at work. It's important that any sort of drug testing that you are performing. Avoid singling out certain employees. Don't use a random drug test as a way to, kind of sniff out, if you will, one or two particular employees. If you have a reasonable suspicion about that policy and you allow reasonable suspicion testing in your handbook or drug testing policies, as you should, document the reasons why you have that reasonable suspicion, make sure they're objective, and then just send that person for a drug test based on reasonable suspicion. Don't go under the disguise of a random drug test. If a business decides to alter its official policies regarding marijuana, we are obviously advising that you make those changes, circulate the handbook or the policies to your employees. You don't even have to say, hey, look, we're updating our marijuana policies. Just at least circulate these updated policies to your workforce. That way they can be made aware of the policies. That's just a really good best practice for employers. Importantly as well here, if you do not have a policy regarding marijuana, or if you do have a policy regarding marijuana, but it's not specific enough, and you were to terminate an employee for some sort of use of that marijuana, and it wasn't a specific prohibition in your policies, as it says in the last bullet point here, those employees could be owed unemployment benefits if you were to terminate them. So we just need to make sure that all our clients, all the employers in Ohio have these detailed, specific policies that clearly spell out what they want to occur regarding the use of marijuana. Another aspect of all this that you might begin to see is some employers in Ohio, it's a fairly good amount, but they subscribe to the drug-free workplace program. And what this program essentially is it's administered by the Bureau of Workers' Compensation. But if an employer subscribes to this program and they maintain a drug-free workplace, including policies, education, the ability to refer employees out in the event of, they become aware of a substance abuse or alcohol issue, they can receive a discount on their workers' compensation premiums. And a lot of employers do subscribe to this. The issue we're having here, and this is yet to be clarified, is there has not yet been an exception made in Ohio under this program for marijuana usage. So theoretically, marijuana still remains, unlawful under this BWC program if you are a subscriber to that program. That may change in the future, but as of right now, marijuana remains a prohibited substance for purposes of this program. Now, with that being said, this program typically does not require drug testing. So although you might prohibit it, you might not have a situation where you're going to snuff it out, if you will, because you don't have a testing program. That's going to be different from the federal government has a similar program that we're going to get to here in a moment. They do require testing, but for purposes of the Ohio Drug-Free Workplace Program, just note that marijuana remains prohibited under that program, but that program does not require testing. So if you fall into that program and you're going back to revisit your policies, definitely, give us a call, give your other employment attorney a call, and we can help you walk through how best to craft your policy to try to remain compliant for those premium discounts. At the same points, realizing that many of your employees are probably going to be consuming recreational marijuana here in about a month. So another common question we get asked about marijuana concerns the Americans with Disabilities Act, and this is where we're going to get to some breaking news here at the federal level. But under the ADA, you do not have, well, let's start here. The ADA, obviously, as many of you are going to be aware, requires reasonable accommodations to be provided to an employee to allow them to perform their job duties to the extent if they have a disability. So a lot of calls we get is, hey, an employee has come, they say, for example, are undergoing some sort of cancer-based treatment. As part of that treatment, they have been prescribed medical marijuana to alleviate some of the effects of the cancer treatment. But we don't want to, let's say they operate heavy machinery. We don't want to accommodate that marijuana usage. Under the ADA, though, do we have to as a reasonable accommodation? As of right now, the answer to that question is no. The ADA specifically says that illicit drugs do not need to be accommodated. The use of illicit drugs do not need to be accommodated. As of right now, marijuana, THC, remains 100% federally illegal. And so therefore you do, I'll just make sure my camera's still up here. Therefore, you do not need to accommodate that use. And again, the same applies at the state of Ohio level too. Ohio is a similar statute, same rules apply there. Now, where this could change is this breaking news is last week, the Department of Justice made an announcement made an announcement that the DEA would begin the process of evaluating whether to declassify marijuana THC from a Schedule 1 all the way down to a Schedule 3, which puts it online with, say, like a Tylenol with codeine type of prescription level. If that final rule is to go into place, which we suspect that it will, that is going to now allow for marijuana to be used as a prescribed medication for your employees. That is likely going to now put it under the purview of the ADA for requiring accommodation at the federal level. So even though Ohio has this exception that specifically says, hey, you don't need to allow medical marijuana as an accommodation, unless the feds implement a similar exception with these changes, you would have to consider medical marijuana as an accommodation under the ADA if it were to be specifically, rescheduled to a Schedule 3. Now, I could talk on that topic itself for hours, and honestly, what that descheduling and the consequences it may have. But one of the main points here first is that declassification would still require some sort of FDA clearance to allow this to be served as a medication at the federal level. So we are likely a ways away from needing to accommodate medical marijuana under the ADA. But I just want to let you know that obviously there is changes coming at the federal level, not only in declassification, but I know that there's bipartisan bills being introduced that would allow for complete marijuana legalization nationwide. But that's a conversation for another day. Next, we're going to cover the Federal Controlled Substances Act. If you are an attendee at this webinar and you otherwise have a federal contract or you are considered a federal contractor, then you need to be aware of that you may have obligations under those contracts to maintain a federal drug-free workplace, similar to the Ohio requirements, right? That you have to have policies on drug use prohibiting it. You have to have education. You have to have referral for abuse, et cetera. But the fourth caveat for the federal drug-free workplace program under the Controlled Substances Act is the fact that you have to do testing under the federal requirements. So you're going to know if you have these federal contracts. If not, you might want to ask around to make sure that you don't have any federal contracts, because if you do, we have to check those contracts to make sure you don't have drug testing requirements. Now, I do want to, obviously we deal with healthcare clients a lot. It's our view that simply being a healthcare provider who receives Medicare, Medicaid, VA funds is not a federal contractor. The federal contractors are going to be the ones that have a specific contract with the federal government or one of its agencies, and that contract will usually state you must follow the Federal Controlled Substances Act, drug-free workplace program. So I just want you to be aware of that if you do have these federal contracts, you may still have an obligation to prohibit the use of marijuana even outside of work hours, and you may need to still continue to test for it. But this would be a small percentage of employers, particularly those on this webinar. But if you are a federal contractor, definitely get in touch with us or your other trusted employment attorney to make sure you don't have to continue to drug test. Obviously, just the consequences. If you are required by the federal government to do a drug-free workplace program and you don't, you can obviously lose your contract. You could not be denied future grants or future contracts. So it's definitely something we're going to make sure that you are adhering to. Another potential consequence of the descheduling from a Schedule 1 to a Schedule 3 would be how the government would view a Schedule 3 medical marijuana under the drug-free workplace program. I suspect ultimately they would allow it to be used. But again, that kind of comes down to probably who's the president and the political party at the time when all this goes into place. Cover the drug-free. We briefly covered this, but I'll touch on this again. But employers considering drug testing, definitely consult with legal counsel to ensure that you're conducting those policies, drug testing policies in accordance with not only their language, but in accordance with law too. Ohio does have some privacy protections for employees when it comes to drug testing, and there's been some ongoing litigation as to, what steps you can take when doing drug testing. For example, can the medical review officer do a direct observation, say, of a urine specimen? How are those records supposed to be stored and kept? So if you are going to continue to do drug testing, this is now a good time to, again, consult with your legal advisor to make sure that your drug testing policies are specific and clear enough to withstand potential future scrutiny from an employee to the extent they're terminated for testing positive. I also want to touch on briefly here for a moment, again, just for our healthcare employers, that state professional boards, there's some considerations made for licensed employees. I will say at this time, every board is different in how they handle marijuana and marijuana type issues. So you're going to want to consult the specific boards for your employees that you have. I will state generally, though, that the healthcare boards that we're aware of primarily take a approach of they're not going to get involved, say, into marijuana usage unless it comes from a position of patient harm, patient risk, or of a substance abuse concern where this person needs to disclose these substance abuse issues. So those boards are primarily taking a laissez-faire approach to the healthcare boards that at least are taking more of a laissez-faire approach to marijuana and only addressing it if it becomes an issue for another reason. That stands in contrast to the Ohio Supreme Court that's responsible for licensing attorneys. The Ohio Supreme Court has actually issued an opinion back following the passage of medical marijuana that said that they still take the view that medical marijuana would still be improper for attorneys, and attorneys could be disciplined for using medical marijuana because it remained illegal at the federal level. That's kind of an extreme approach based on the language of our specific code of regulations for attorneys. But the Ohio Supreme Court takes that more severe approach. I will say that they're in Ohio, at least that we're aware of from a board perspective, they're the most severe or most strict with marijuana. Everyone else kind of, again, falls into that laissez-faire approach. Covered that. So that is really our presentation for today. Again, I really wanted to open this up to questions or concerns that you all may have regarding changes to policies, where we see this going, kind of what you're thinking maybe on divisions of certain groups of employees being allowed to use versus others. But I'll hang around here for a little bit and see if any questions or comments come in. I think I see one here now. Oh, the PowerPoint is minimized, but still visible. I hope that didn't last too long. Try to make this bigger here. Okay. But like I said, I'll hang around here for a couple of minutes. If not, if you need to head out, please feel free. We like to keep these webinars during the week at the lunch hour short to, minimize the time taken out of your day learning about these topics. Oh, here's a question right here. As an employer of attorneys, I'm interested in the OSC's position. Have any lawyers been disciplined for getting medical marijuana cards? That is a great question. The answer to that is I am not aware of any employers being disciplined for using medical marijuana. I know, again, the Ohio Supreme Court has threatened discipline for using medical marijuana. And it's interesting because, the medical marijuana database does exist. So unlike recreational, where theoretically it's going to be more of an anonymous type purchase, to use medical marijuana in Ohio right now, you have to have a card, right? And there's a database of who has that card that theoretically the Supreme Court could potentially get access to. And now that warrants its own privacy concerns and potential litigation. And maybe that's why this hasn't gone further. But as of right now, the Ohio Supreme Court has said that the use of medical marijuana by lawyers does remain an ethics violation. They did add a caveat to that said, we're not going to specifically approve it, and it is an ethics violation, but they don't see a world where they're really going to be punishing lawyers solely for using medical marijuana. They would have to take a secondary act as well, such as, distributing it, selling it, giving it away, taking it across state lines, or otherwise having it jeopardize, their practice of law, then they're likely to get involved. But they do still reserve the right to get involved if they become aware that an attorney has a medical marijuana card. But again, we're not aware of any situations where the Ohio Supreme Court has come down on that yet. So with that, like I said, I'll hang around here for another couple questions, but my contact information is also on the screen. So if you want to discuss your drug testing policies or how you might be able to amend your policies to account for marijuana, again, we're only 3 to 4 weeks away from this being widely available in the state of Ohio. So the time to begin that process is now to make sure you can have those amended and communicated to your employees before recreational sales go online next month. I'm not seeing any other questions at this time. So we'll probably end it there then. I really appreciate everyone attending today. And like I said, feel free to reach out to me via phone or email on the screen now to the extent you have any other questions. Hope you all have a great rest of your day.